Welcome back. In this last session on the subject of competition law in India, we will look at the working of Competition Commission of India, and in the course of which certain areas of concern will also be highlighted. The Competition Commission of India, or the CCI, celebrated its 10th annual day on 20th May 2019, which marks the notification of the substantive enforcement of the Competition Act 2002. On the occasion, it was stressed that in view of rapid change in technology day by day, disruption in services and products have become a new norm in the markets, and dynamic role of the Competition Commission of India is required for its regulation. The CCI has been established as an expert body performing the role of independent regulator or a watchdog for the economy in the same manner as SEBI is for capital market. In the course of its functioning, CCI undertakes executive adjudication in juxtaposition to judicial adjudication in respect of all aspects interested under the Competition Act. However, as held by the Supreme Court in Mahindra and Mahindra vs CCI, merely because CCI performs adjudicatory function, it does not acquire the character of a judicial tribunal or a court. The Supreme Court previously in 2010 in CCI vs SAIL had noted that the CCI is vested with inquisitorial, investigative, regulatory, adjudicatory and advisory jurisdiction under the scheme of the Act. With respect to quasi-legislative function, CCI is empowered to issue regulation for discharging its function. However, there is a lack of procedural framework to guide the issuance of such subordinate legislation. The Competition Review Committee has therefore stressed on the need to have such a framework, including public consultations and periodic review to ensure transparency and accountability. The CCI is in parts administrative, expert having regards with advisory and advocacy roles, and quasi-judicial when it proceeds to issue final orders, direction and penalties, and hence is thus not purely a judicial tribunal but discharges multifarious functions, one of which is adjudicatory. The Supreme Court in Menka Gandhi vs Union of India emphasized the importance of adoption of fair, just and reasonable procedure by judicial and administrative authorities. While Section 36(1) of the Competition Act unequivocally provides that the CCI can regulate its own procedure, it shall be guided by the principles of natural justice. The same with respect to CCI was reiterated by the Supreme Court in CCI vs SAIL in 2010. Principles of natural justice has been held by the Honorable Supreme Court as an integral part of the procedural safeguard evolved by the courts against arbitrary exercise of power by judicial, quasi-judicial and administrative bodies or authorities, and any violation of the rule of hearing and the rule of bias predetermination has the effect of vitiating the final decision or order. On multiple occasions, however, CCI has erred in the compliance of principles of natural justice. CCI has in past ignored basic due process of law, and such decisions have been challenged in appellate forums and were set aside by the erstwhile compact. In order to impart a sense of faith and responsibility in the system, it is vital that CCI orders are in consonance with the law in letter and spirit, substance and procedure. Another issue that mars the competition law enforcement in India is the jurisdictional tussle between sectoral regulators and the CCI. Competition law is supposed to be orthogonal in nature, and which means that the jurisdiction of CCI is not restricted to any specific sector or field of business. The CCI has a wide mandate to eliminate practices having adverse appreciable effect on competition and to promote and sustain competition in the market in India. In the recent history, there have been multiple occasions where the jurisdiction of the CCI has been questioned and pitched against jurisdiction of a sectoral regulator. The Delhi High Court order of 2017 quashing the CCI's probe in cartelization by the telecom companies is an example. The court held that the issue fell within the exclusive jurisdiction of TRAI. Most of the sectoral laws, either in general terms like that in Telecom Regulatory Authority of India 1997 or Petroleum and Natural Gas Regulatory Board Act of 2006, or in specific terms like in Electricity Act of 2003, incidentally have placed competition goals with the regulator. These regulators have a mandate to maintain competition and promote efficiency in the sector. The Competition Act of 2002 does not have any provision that can resolve this issue or overlap and conflict of jurisdiction. Under the Act, while the non-obstante clause under Section 60 gives it an overriding effect, Section 62 requires harmonious interpretation of statute with other laws. The CCI under Section 21 or 21A may consult other sectoral regulators. However, the mechanism is voluntary and has not really helped in the past. Needless to say that the mandates of sector-specific statutes and the Competition Act is different and is formed to achieve different outcomes. Sectoral regulators are more concerned with structural changes and therefore employ an ex ante assessment of facts, while Competition Authority mostly does an ex post assessment. The overlap of jurisdiction not only duplicates the deployment of efforts and resources, but also creates uncertainties of outcome. While the CCI has on multiple occasions assumed jurisdiction despite the presence of a competition mandate within the sectoral statute, its jurisdiction to investigate has also been set aside by high courts on many occasions. There needs to be a solution to resolve conflicts of jurisdiction by adopting either the exclusivity or the concurrence model. The compact in Dakshin Haryana Bijli Vitram Nigam and others held that the Electricity Act of 2003 had an overriding effect over the Competition Act of 2002 despite the non-obstante clause. The Supreme Court, however, in fast-way transmissions held that Section 60 of the Act gives it an overriding effect in case of a clash with other statutes, keeping in mind the economic development of the country as a whole. The Supreme Court has recently, in Bharti Airtel Limited and others, favoured a balance of jurisdiction between sectoral regulators and the CCI. The Supreme Court took a middle path and balanced the stand by giving TRAI the power to determine the rights and obligation of the parties first, and then if it is apprehends the existence of Anti-Competitive Act, invokes the jurisdiction of CCI. The pronouncement by the Supreme Court is likely to have its impact on sectors like banking, equity, insurance, petroleum and electricity. Following the Supreme Court opinion in Bharti Airtel, the CCI has recently closed the matter of the NSE co-location case as it was currently under investigation by the SEBI. The MCA is now considering setting up a forum of regulators so as to create a platform where bodies such as CCI, TRAI, CRC, IRDA and PNGRB can meet and resolve issues like jurisdictional overlap through discussions. One of the mandates of Competition Commission of India is to build a competition culture. The competition culture will be the key to achieve long-term sustained economic growth. Corporates need to be proactive in compliance. Old business practice needs to change to ensure that the enterprises do not have to face inquiry by the Commission. Promoting a competition culture in the economy would necessitate a comprehensive review of active laws and policies through a competition lens and bringing out necessary modification if required. The CCI, under its mandate of promoting and sustaining competition, has created an institutional framework for assessing select economics legislation and policies, both existing and upcoming, from a competition perspective and sharing the findings with the concerned stakeholders. The CCI has come out with Competition Assessment Toolkit, which provides a standardized and simplified expression of principles that can be used for identifying competition concerns cutting across all sectors. The objective is of sensitizing policymakers toward competition concerns cutting across sectors and legislations and promoting a competition culture by ways of non-enforcement mechanism. To help enterprises in developing a competition culture, a compliance manual for enterprises has been launched. In addition, do-it-yourself online guidance system for determining notifiability of merger and acquisition have also been launched. The compliance manual, however, does not distinguish between sectors or size of enterprises and companies, and the companies may adopt customized compliance programs. There is no government-approved standard for compliance. Success in building a competition culture has obvious benefits for enforcement. Businesses will more readily comply voluntarily with the competition law. Business and the public will more willingly cooperate with enforcement actions by providing evidence and the like, and policymakers will more enthusiastically support the mission. The challenge still remains to strengthen competition awareness among market players, thereby encouraging self-compliance and reducing the need for direct action against erring enterprises. It has been noted that while bigger and more organized business entities have started to work on their compliances, the smaller players of the market still lack awareness of the consequence of non-compliance. Apart from regulating market conduct, competition issues due to legal and policy gaps, either due to presence of competition distorting policies or absence of policy, has to be tackled in the coming time to build a competition framework. Cases in sectors like telecom, auto parts, real estate, coal, pharmaceutical, etc. has presented challenges in the past due to either over-regulation or non-regulation of the sector with respect to competition. Improper or sufficient regulation leads to anti-competitive conduct. CUT's report identifies this issue and has stressed on the need of a comprehensive national competition policy in India. Pradeep S. Mehta, Secretary General CUTS International, lamented that tragically that Competition Review Committee did discuss but did not suggest implementation of the draft national competition policy, which would have ushered in structural reforms in the economy, a dire necessity in today's slowing economy. We will have to wait and see if such an exercise is taken in future. Another issue that faces the CCI is the quantum of penalty. The CCI is empowered to pass appropriate orders, including orders imposing penalty under Section 27 of the Act. While the debate on the understanding of turnover to mean average turnover or relevant turnover got resolved by the Supreme Court in Excel Crop Care Limited, where the Supreme Court held that for multi-product companies, adopting the criteria of relevant turnover for the purpose of imposing a penalty will be more in tune with the ethos of the Act. The issue relating to methodology for quantification of penalty is still unresolved. Determination of appropriate percentage of penalty has to be based on set of aggravating and mitigating factors. The CCI has to take inspiration from fining guidelines of UK or US to formulate its own set of guidelines. Fixed parameters of quantification of penalty will bring in objectivity and consistency to the decision making of the CCI. The Competition Review Committee deliberated on the issuance of penalty guidelines. Committee also noted the disproportionate sum of penalties imposed by the CCI in absence of clear guidance of computation of penalties. Last but not the least, one of the challenges with the CCI is facing new market dynamics. The interface of digital market with competition law has presented new challenges to enforcement of competition law. The presence of numerous relevant markets having multiple sites makes the technology sector different than the other sectors. Payal Malik, economic advisor to CCI, pointed out the difficulty in delineation of relevant market. Markets are such that given market at one point of time mutates into another through the exploitation of complementarities. Therefore, a nuanced assessment has to be adopted by taking into account the facts, market and technology in question. With the advent of big data and digital markets, data-rich entities are able to generate more user data with the help of feedback and monetization loops. These lead to concerns of abuse of market power, algorithm and collusion, etc. The competition law and the commission as such has to be prepared to respond to competition challenges presented by new age markets of artificial intelligence, algorithm, business models and online or virtual markets and market platforms. Whether and how the Competition Commission of India resolves and faces these challenges in the coming times is something we'll have to wait and watch. Thank you for being with us in the entire session for competition law.